So it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that. A president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.